Poor Dave. You never really got into video work and all that stuff, so I'm pushing the boundaries of your comfort zone, right?
I'm a different generation.
Well, welcome back to the show. I'm James Bergstrom with Paramount Real Estate Group, and I'm excited for today because we're kind of taking a different route. We've got a new little podcast studio, and I have the privilege of introducing one of my all-time favorite people and I met in real estate way back at the beginning of my career. Today, I'm bringing Sir David T. Bastian, Esquire, JD. I affectionately gave him that nickname years and years ago. On the show here, Dave, welcome on board, brother.
Glad to be here, James.
Yes. Poor Dave. You never really got into video work and all that stuff, so I'm pushing the boundaries of your comfort zone, right?
I'm a different generation.
I'm loving it. Well, let me say this. Dave has been a huge part of Paramount since the last 2.5 years, and I remember the day that we had him come visit at one of our team meetings, and we made it specifically about a specific case. So we studied the case law in this case, and we talked about it as an office, and it has a really interesting, well, story and then outcome. And I kind of think it would be cool to regularly take deep dives on deals because real estate is very complicated. It's a complex business with so many situations. And anyways, Dave's been the designated broker here at Paramount, like I said, for the last 2.5 years. If Paramount was Star Wars, he'd be Yoda.
Inspect you must, or find trouble you will.
Ooh, yes. We are so blessed to have him. He's one of the greatest minds I've ever met and people. And again, welcome on the show, Dave.
Yeah, thank you.
I thought we could take him down a little ride on that old case that we talked about way back in the day that you, shortly thereafter, we introduced you as the designated broker here.
Well, the case that we were talking about is called Douglas v. Visser. And what happened in that case is Visser, who also was a real estate broker, decided to buy a piece of property, and he was going to fix it up and then use it as a rental. But as he got into the fixing up process, he was running into a lot of problems. And in this case, what happened was the Douglases purchased this home from them. They got their own inspection, which indicated a couple of problems. But they ended up closing that transaction. And not long after purchasing the property, they started smelling a dank smell, and they had potato bugs coming in the house. And as they tried to address some of those issues, what they discovered was that the extent of the problems ran way deeper than they had expected. And as they tried to correct problems, every time they would try to correct it, they would find out there were additional problems. And so then they began investigating it deeper and deeper and discovered that there were a lot of things that were covered up. And the evidence in the trial, the court actually says in that trial that the sellers falsified their seller disclosure statement. They actively covered up things that they knew that were wrong. For example, rotten floor joists had been sistered together. Insulation had been placed in the walls so that when an inspection happened, you wouldn't discover the rot in the walls. Testimony from some of the contractors that Visser had hired testified that they were bringing to the attention of the seller, the Vissers, that the floor joists were rotten, that the sills were rotten, that when they pulled off a belly band off of the house, they could pull it off with their hands. And when they were instructed to, or when they asked about fixing it up, they were told to cover it up, or when they said, hey, we can't get a nail into the wood, the answer was put more nails in. And so it was just actively covered up.
Right.
So we have lying on the seller disclosure statement, and we have an active cover up. And you would think that that the buyer's going to have recourse. And at the trial court level, they did. So the trial court found that there was fraudulent concealment and misrepresentation of the property, and awarded them relief at the trial court level, and then it was appealed to the appellate court. And the appellate court went consistent with Washington law, and that is that if there's something wrong and it's discoverable, then it shifts that burden to the buyers. And in this case, the buyer had their own inspection done, and there was evidence of some leaking up around the roof area, and there was evidence of some moisture and wood rot on a sill down in the crawl space. And because these buyers were aware of this much of a problem, it means that they were responsible for the entire problem. So the court held that the fact that the extent of the problem goes way beyond what you discovered is not a new problem. It is the same problem. So you discover a dime, you're in for $1. And the appellate court actually reversed that decision. The Vissers were not held liable, even though they lied and covered up, because the buyers knew about some portion of the defect. They were held to know all of it. And the court says that, and really focused on the fact that these buyers did not ask additional questions. They should have further investigated. You can't just say, well, I see a little bit of a problem and I'm going to ignore the rest of it. So the outcome of that case, it was completely reversed, and the Douglases had to tear the entire home down. And it was completely shifted to the buyers in this case. And this is really consistent with Washington law, and that is if it's discoverable upon an ordinary and reasonable inspection of the property, then the buyers are pretty much going to own that problem. And in our business, we try really hard for sellers and buyers to go down the road and both be happy. But when I get calls from buyers, it's usually because after they've moved into the home, they've discovered something. And so then the next question is, well, was it discoverable on your inspection? And if it was, the buyers are not going to have a lot of recourse.
Right.
And unfortunately, a lot of the buyers, they call and they say, there's no way the sellers could not have known this. It was obvious. And the hard answer to that is, well, if it was so obvious, how come you didn't know about it? And so just a really difficult situation. And the takeaway for us is that as brokers representing buyers, we need to not be interpreting that inspection report, but encouraging our clients, the buyers, to be fully engaged in that inspection report, read it and ask questions of the inspector, and follow through if they have questions. They need to continue to ask questions.
Yeah, due diligence. Buyers, so important. I mean, this is astonishing, Dave, when you think about, because I'm sure that family didn't know. You know, they may have knew a little, but to have someone bold-faced lie in a disclosure statement and then someone else pay the price for it is so sad. But that's, I mean, it's critical. It's critical when we're representing buyers, or buyers in general out there. Do that work. Get those inspections. I mean, you know the climate since 2020. So many, for a long period there, home inspections were being waived in order to get the deal because it was such a competitive market, but things are starting to balance out, you know, where we have more inventory now, And but yeah, that's a great lesson for many to understand and know. So when comes time for them to take part in this process, they do their due diligence to the full extent. Home inspections, additional inspections. I mean, we've had some complicated deals, Dave.
We have.
We have, especially lately.
It's really important you get the right person for the job, and that you have the right expert out there. You know, we as real estate brokers, we are experts at negotiation and drafting contracts and bringing a transaction to a close, but we are not experts when it comes to inspecting homes. We're not experts as to title and many other things, but what we are supposed to do for our clients is be kind of the hub in the transaction and be able to connect our clients with the expert that they need at any given time. And we're good at that as a company. We've got a lot of connections of people that are very good at what they do. And we connect our clients with them, and then the clients need to rely on those experts and make sure that they are satisfied before closing and that all their questions have been answered. But you know, when it's a competitive situation and we're going into a multiple offer situation, it is very tempting to waive your inspection. As a seller, I would rather have a buyer do an inspection because I want to be transparent. I want the buyer to feel good about this transaction, so I want them to do an inspection. And then in terms of when the transaction's over, it's also good for me as a seller to, if something did come up, I would be able to say, look, I allowed you an inspection, you in fact did an inspection, and you know as much about this property as I do. You know, and so I think inspections are important for sellers and buyers, and they ought to avoid the temptation of not asking for an inspection. And if they want to compete in a multiple offer situation, then maybe do a pre-inspection. Get out there before you even make your offer, get permission from the seller to go on the property and conduct your inspection. Then you can be satisfied with the condition of the property and make your offer without an inspection contingency. But do not recommend doing it without an inspection.
Yeah. Well, you know, Dave, like I said earlier, I'm thankful because I've now been a real estate broker for 25 years. And at the beginning, I started with you. And I can remember back in the day, just learning from you and walking in your office, your door was always open. And if I drafted something up, I'd run it by you and show you, and you would give me that thumbs up, looks great, or hey, here too. Putting your little JD-isms in there. For those of you that don't know, if you haven't figured out, Dave's also been a real estate lawyer for 36 years?
36 years this month.
Hey, I hit it on the head. And you've been a designated or managing broker for
25 of those. 25 years.
Dude, I just love you. I'm so happy to have you here and doing this journey together. It's been so much fun here at Paramount, hanging out, teaching, educating, lifting people up, supporting people.
Well, we want to be known as the most educated, best trained professionals in the business, and we are always committed to doing the right thing.
100%.
And that's why I love being here and working with you, because you're committed to the same things that I am, and we have fun.
We do.
Yeah, I'm very proud to be here.
Thank you, brother. Well, if you enjoyed watching this, make sure and hit like and subscribe. That's all for now, but till next time, peace, love, and light.